Raymond. Okay, it's 4:30, so welcome to the last session of the Modern History Research Center seminar talks, and you are all very welcome, and it's nice to see that we have a good turnout in campus, particularly out of term. That's really great. And we have also people at home, so that's fantastic. And for those at home, we are already recording, and as usual, the recording will be later in our YouTube channel. So we have today our very own Michael Alexander, who's going to talk about Britain, the Commonwealth, and the Tokyo trial, a new transnational approach. Before giving him pass the baton to Michael, I wanted just to give a few words saying that we have a really very good year in the Modern History Research Center. We have 6 wonderful talks, and we started a new approach on booking for the seminar, for the attendance, and we are now, gathering subscriptions, and we accept donations too, so please bear us in mind. And we are preparing now the program for next year, and we have already in the list of talks a very interesting talk by a colleague in the American University of Bulgaria, Marcus Vine, who's going to come and give us a talk about life after socialism. And we have also a student, a PhD student, Susan Birch, who's going to give us a talk about support before the pill, the Family Planning Association between 1945 and 1955. And we are already preparing other talks. So our idea is to continue with this range of at least 5-6 talks per year, and also other activities. We are going to be in the Research and Innovation Initiative of the university in September with a panel with Javier Guegan and also Lisa. And so please follow us, and I'm very grateful for all your support, and we keep on connecting through the email. So if you are not in the mailing list, be sure of letting us know. Our mailing address is mhrc@winchester.ac.uk. So that's as much as I wanted to say before giving the word to Michael.
Thank you very much. Okay, thank you everyone for coming to my talk today. I'll be broadly covering the first 2 chapters of my PhD on Britain, the Commonwealth, and the Tokyo trial. I'm currently around halfway through my part-time PhD, and overall the project is very much a work in progress. I'd welcome any feedback once we get to the end. And
there we are. Yes, it's the Teams that tends to confuse us. Right. We should be in the slideshow version from beginning. I should be. Why is not doing it? For some reason here in this laptop is showing something different.
It says resume slideshow there.
Okay, let's do that. It's not doing it. It's the usual problems that we have. Now, I'll stop sharing and start again, okay, to see if that will help us. Okay, let's see. And let's put resume slideshow. Okay, we'll get there. We'll get there somehow. We'll get there somehow for some reason. Why is not refusing to do the, yeah, it may be that it's doing it twice for some reason. Let's get out from here. It's refusing it. Ah, there we are. Hopefully, I hope people at home can see it. Otherwise, we'll have to give priority to the people here in campus. So there we are.
Brilliant. Right, yeah, all working. So here's the structure of my talk, which is broken into 5 sections. Firstly, I'll give a brief introduction to the Tokyo trial and some thoughts on why it is still a topic in need of further research. Then I'll provide a review of 5 key texts on the trial, considering their aims, strengths and weaknesses, and indicating where there are gaps for further research. Next, I will discuss the jurisdiction of the Tokyo trial, which will establish the purpose of it, Then I'll introduce some of the key personnel involved in it before making some preliminary conclusions about the Tokyo trial based on my research so far. So on the screen, there is a fact sheet of sorts about the Tokyo trial containing some key information about it, which I will now go through. So firstly, what is the Tokyo trial? Officially called the International Military Tribunal for the Far East, it was the second of two post-war international military tribunals, the first one being the Nuremberg trial. The Tokyo trial was established for the just and prompt trial and punishment of the major war criminals in the Far East, who as individuals or as members of a group are charged with offences which include crimes against peace, conventional war crimes, and crimes against humanity. Interestingly, and something which differentiates the Tokyo trial from its Nuremberg predecessor, is crimes against peace were a prerequisite prosecution, meaning only those who were charged with crimes against peace could stand trial. After a period of deliberation which saw each Allied nation asked to produce a list of suspects, 28 Japanese suspected war criminals were selected. This number would then be reduced to 25, with 2 dying and 1 being deemed mentally unfit to stand trial. Now moving on to who were involved in the trial. General Douglas MacArthur, as the Supreme Commander for the Allied powers, presided over the Tokyo trial, having signed the instrument of surrender, while the Special Proclamation and Tokyo Charter were published in his name as SCAP. To what extent he was actively involved in the trial will be considered later on when we do a brief biographical sketch on him. Next, there are a raft of prosecutors, all led by the American Chief Prosecutor Joseph B. Keenan and his 11 associate prosecutors from each of the Allied nations involved. On the other side of the courtroom, the defense counsel consisted of American and Japanese members. As for the judges, there were originally only 9, 1 for each of the signatories of the instrument of surrender. So that was Australia, Canada, China, France, United Kingdom, the Netherlands, New Zealand, the USSR, and the US. This was eventually expanded to include India and the Philippines, after Britain and its dominions campaigned for the addition of India to recognise the Indian contribution to the war and to try and increase the Asian representation on the judges' bench. After some back and forth between Britain and the US, it was eventually agreed that India would be added, with the caveat that America also allowed to add the Philippines. The simplified outcome of the Tokyo trial is that after more than 2.5 years of the trial, the majority judgment found all of the remaining 25 defendants guilty, handing out prison terms and executions. However, alongside the majority judgment were 5 separate opinions showing a fractured judges' bench. On the screen now are some of the reasons why the Tokyo trial has lacked intellectual discussion and attention given to the Nuremberg trial in the West. From the conclusion of the Tokyo trial, discussions surrounding it were stunted in English-speaking countries due to the UK and US governments failing to publish the proceedings or judgments. There are multiple reasons for why this may have been, including when the trial had finally finished, the governments were otherwise occupied with things such as the Cold War, and the governments may not have wanted to acknowledge the trial, especially after it became apparent there were 5 separate opinions detracting and undermining at times the majority judgment. This lack of English primary sources, or English language primary sources rather, was not rectified until 1981 and led to a lack of texts and discussion surrounding the Tokyo trial outside of Asia. Then the first text to discuss the trial in depth was Richard Munir's Victor's Justice, which was published in 1971, and it presented the trial as a complete failure. As well as the lack of primary sources, the Tokyo trial is often viewed as secondary to the Nuremberg trial, both literally and in standard and importance. Being the second international military tribunal after World War II led to people quickly becoming lethargic, especially when the Tokyo trial began to drag on. Also, the defendants of Tokyo did not have the name recognition of their German counterparts, partly because they were committing their crimes for the most part far away from the West. Even the president of the Tokyo trial, who I'll come on to later, conceded that the crimes of the German accused were far more heinous, varied, and extensive than those of the Japanese accused. Now I'll do a brief kind of a look into my research and where it fits in. So my thesis will consider the contributions of the British Commonwealth judges and prosecutors towards the proceedings and judgment of the Tokyo trial. This will include highlighting personnel who have up until now been mostly sidelined. Also, I will analyse to what extent the Tokyo trial is accurately portrayed as one of the following 3 things: an American performance, an Allied undertaking, or is being dominated by the British Commonwealth. My research is in line with the broader historiographical shift surrounding the context of the Allied occupation of Japan, with the growing consensus in this historiography being that while it was US-led, the Allied contribution to the occupation was more than they were previously given credit for. I believe the Tokyo trial is similar, and the historiography is going in a similar direction since 2008. While the trial may have been dominated by the US when it was being set up and established, the Allied contribution to the trial during the proceedings is worthy of further acknowledgement and credit. To what extent the trial was an Allied undertaking and who is most deserving of the credit are things my research will investigate. Primary source analysis has been undertaken, including looking at the Potsdam Declaration, the Instrument of Surrender, the Special Proclamation, and the Charter of the International Military Tribunal for the Far East, with the latter being more commonly referred to as the Tokyo Charter. All of these have been looked at for my chapter, which introduces and traces the jurisdiction of the Tokyo trial, which I'll be covering in later slides. I've also looked at the transcripts of the proceedings in chambers and the transcripts of the entire Tokyo trial, although these two are both works in progress as they amass to over 49,000 pages. To further identify the gaps I'm trying to fill, we'll move on to a brief historiographical review of 5 key texts. So beginning with Richard Minear's Victor's Justice, which I spoke briefly about earlier, this was the first English language book-length study of the Tokyo trial when it was first published in 1971. It achieved significant success to the point where the term Victor's Justice is synonymous with the Tokyo trial now. However, the book is also a product of its times, as Minear repeatedly refers to the ongoing Vietnam War and what he perceives as America's questionable actions during that war. As a result, Minear has clear anti-war sentiments which bleed into the book throughout. This is apparent also in Minear's aims of the book, which, from his own words, were to challenge the prevailing image of the trial and to demolish the credibility of the Tokyo trial and its verdict, all with the aim of learning from our mistakes. This also summarizes the openly critical nature towards the trial, which is apparent throughout the book, with Minear believing the trial was highly defective. Some of the reasons he gives for this view is that the judges were appointed purely from the victorious nations over Japan, and he believed that those judges appointed lacked relevant experience and skills in international law. Furthermore, he also believed the inclusion of crimes which did not exist in international law at the time the Japanese defendants are accused of committing them undermined it. Overall, Minear remains a pioneer in the field and has gone on to inspire several texts through the debates over whether the Tokyo trial is an example of Victor's Justice. And it remains an interesting and important read. However, the heavily opinionated nature of the book means Minear fails to adequately consider whether the Tokyo trial was a success in any way. And as a result, the book needs to be understood within the context of the motivations of the author, which again were to discredit the Tokyo trial. Next, we have Neil Boyster and Robert Crier's A Tokyo Trial, a Reappraisal, which provided a timely reassessment of the Tokyo trial from a legal perspective, using their background as lawyers to distinguish their study from Minear's, whose analysis of the trial's legality fell short of their expectations. Moreover, and further distinguishing themselves from Minear, Boyster and Crier attempt to remain impartial or at least stay away from any strong opinions in their book. Instead, their aim is to equip the reader with the knowledge to draw conclusions for themselves. The biggest benefit of the text is the legal focus. However, this is also its primary limitation, as Boyster and Crier, from the off, explain that they are not historians and therefore refrain from engaging in much historical analysis. That being said, it's a helpful reference point from which a wider reassessment of the Tokyo trial can be made from, and it did help provide a more balanced reappraisal of the trial, helping reinvigorate the field. Next is Yuma Tatani's A Tokyo War Crimes Trial, The Pursuit of Justice in the Wake of World War II, which attempted to assess the historical significance of the Tokyo trial, explore some of the central misunderstandings and historiographical distortions which have plagued the trial, and to provide a counter to the dominant historiographical view that the trial was Victor's Justice. Therefore, this book sides, or more so sides with Boyster and Crier in trying to steer away the historiography away from the shadow of Minear's Victor's Justice. The most impressive strength in this book is the melding of Asian and Western historiography, providing a review of some important Asian texts on the Tokyo trial to a Western English-speaking audience, who may have otherwise not been able to access them. This enabled Tatani to develop the understanding of victor's justice and the Tokyo trial from more than just a predominantly American perspective for the English-speaking audience. In addition, Tatani manages to draw comparisons between Asian and Western texts, which previously had not been noticed. For example, Tatani compares the immediate post-trial nationalist views of the Tokyo trial in Japan, who questioned the legitimacy of victorious nations judging the vanquished, and the use of laws which they believed had been created by the victors to aid their revenge agenda. And Tatani compared that with Richard Minier's Victor's Justice, commenting that the Japanese nationalists had received an accidental ally in the American Minier. Where the book falls down with reference to my study and research is it only contains fleeting discussions of personnel, with it only really focusing on the chief prosecutor and the Indian judge. Next, we have Yuki Tanaka's Beyond Victor's Justice, the Tokyo War Crimes Trial Revisited, which acted on something Boyster and Cryer requested, which was a Western reassessment of the Tokyo trial. They did this by bringing together an international collection of scholars from multiple disciplines to discuss the Tokyo trial critically and try to move beyond the dominant narrative of victor's justice. The edited collection at times follows a biographical and thematic approach, with chapters dedicated to discussing 5 of the 11 judges in Tokyo, with depth fluctuating. Alongside this were chapters focusing on important topics about the trial and international criminal law, such as command responsibility, which it is argued in the book is one of the clearest examples of Tokyo's legacy on contemporary international criminal law. Meanwhile, 3 chapters are dedicated to gender crimes, critiquing the failure to prosecute crimes relating to military prostitution during the Asia-Pacific War, and this represented one of the first times this submission was discussed in detail. At times, the breadth of the book limited its ability to go into depth and make meaningful conclusions on aspects of the trial. For example, when introducing and discussing the 5 judges, the United Kingdom's judge was only afforded 4 pages, while Australia's judge, who was also the president of the tribunal, is not afforded a dedicated chapter at all. I would argue also that this book was largely overshadowed by the next one, which was also an edited collection involving the scholars from around the world, and which went a little bit further in discussion surrounding key personnel and themes, as I'll show now. So the book which I was referencing is Kirsten von Lingen's Transcultural Justice at the Tokyo Tribunal. And in the author's own words, it intended to provide a reassessment of the Tokyo trial by contextualizing those involved in it, highlighting the transcultural and human aspects of the trial, and refocusing the historiography on the individual nations at the trial who had traditionally been sidelined as minor players. Overall, the book is a lot more human-focused in its analysis of the trial, with dedicated chapters on each of the 11 judges, which was a timely and needed addition after several publications focused on the legal side of the trial mostly. I think this book builds upon the previous one by Tanaka, going further by ensuring each judge is discussed in a dedicated chapter alongside relevant themes to their countries, again in differing detail, whilst also discussing some of the prosecutors and defence counsel too. This book is also the closest to my area of research, given its discussion of the personnel involved in the trial as part of its focus on the transcultural and human aspects. And the shared focus on the transcultural nature of the Tokyo trial is seen through one small example of that is the shared focus on the emergence of a British Commonwealth bloc during the trial, which many believe was influential in the majority judgment. However, despite this book discussing every judge, gaps in the historiography persist. For example, the chapter on Australia's Judge President William Webb fails to make any new analysis or conclusions about his contribution to the trial, something that the author themselves admit. The final book I'll look at is Gary Bass's Judgment at Tokyo. And in his own words, this book was to document the inner workings of the Tokyo trial, its law, its politics, and its long shadow. And he wanted to enable readers to make up their own minds about how the trial worked and what it meant. Gary Bass's contribution to the historiography is, in my opinion, monumental, both in size, scope, and readability. The book, despite covering 33 chapters and nearly 700 pages, not including indexes, notes, or the bibliography, manages to maintain the reader's interest. This is largely thanks to the author's ability to maintain an impressive pace throughout, thanks to succinct chapters which manage to capture the drama of the Tokyo trial, the personnel involved in it, and some of the trial's aftermath. I am sure this will be a vital reference point for future studies of Tokyo Trial, with it also possibly having the largest scope of any book I've read about the Tokyo Trial. When making this, I was hard pressed to find any weaknesses, and so I consulted some book reviews, and the only thing I could come up with was the absence of more chapters considering the aftermath of the Tokyo Trial and the individuals involved in it. There are a few chapters on this, focusing mainly on the lives of the judges from China and India following the trial, but perhaps having a section dedicated to this would have capped off what is, in my opinion, an amazing book by fully considering the legacy of the Tokyo Trial and each of the judges involved. Also, as a result of the purpose of this book to help equip the readers with the necessary information to make their own conclusions, Bass does not always make final conclusions regarding, for example, he does not make a final conclusion regarding where power was concentrated during the Tokyo Trial, something which my study will be looking at. And now we're moving on to the next section, which will look at the jurisdiction of the Tokyo Trial, showing how it was established and developed through the Potsdam Declaration, the Instrument of Surrender, the Special Proclamation, and the Tokyo Charter. Firstly, beginning with the Potsdam Declaration, which was published on the 26th of July 1946, and was jointly signed by the Republic of China, the United Kingdom, and the United States of America during the Potsdam Conference. The chief prosecutor of the Tokyo Trial, Joseph B. Keenan, considered the Potsdam Declaration as the foundation of the Tokyo Trial, as it represented the Allies publicly stating their intention that stern justice shall be meted out to all war criminals. Next, the Instrument of Surrender, which was drafted by the US States, War and Navy Departments Coordinating Committee, as per their role to help coordinate US foreign policy related to the occupation of Japan. This was signed on the 2nd of September 1945 by a Japanese foreign minister and army general in place of the Japanese emperor, who was spared any further embarrassment of having to sign the instrument himself. And as you can see in this photo, it was signed by General Douglas MacArthur in his role as Supreme Commander for the Allied powers. The instrument's relevance to the Tokyo Trial is twofold. Firstly, it recognized the Potsdam Declaration as a key document behind the jurisdiction of the Tokyo Trial, referencing the provisions of the declaration in the opening paragraph, before committing the emperor and the Japanese government to assist wherever possible in carrying out the Potsdam Declaration in the 6th paragraph. Secondly, the instrument also established Japan's unconditional surrender, which Neil Boyster and Robert Cryer believe gave the victorious Allies the right to rule Japan as they pleased, channeled again through the role of General Douglas MacArthur. The special proclamation published in General MacArthur's name on the 19th of January 1946 formally established the Tokyo Trial for the trial of those persons charged individually or as members of organizations or in both capacities with offences which include crimes against peace, as well as stating that the Tokyo Charter would establish the precise jurisdiction, constitution, and functions of the trial. Overall, the special proclamation reads as a streamlined version of the London Agreement, which was the precursor to the Nuremberg Charter and Nuremberg Trial, as both documents established an International Military Tribunal, stipulated that their respective charters would then establish the constitution, jurisdiction, and functions of their associated trials, and committed that neither trial would impede locally organised courts to take place. Lastly, the Tokyo Charter provided logistical and legal information on the trial's conduct. The first article established a just and prompt trial and punishment of the major war criminals in the Far East as the purpose of the Tokyo Trial, directly referencing Article 1 from the Nuremberg Charter. Then, Article 5 stated that Far Eastern war criminals who as individuals or as members of organisations are charged with offences which include crimes against peace, thereby establishing who the persons and offences the trial had jurisdiction over. Developing this, the Charter listed conventional war crimes and crimes against humanity as being within the jurisdiction of the trial, alongside crimes against peace, providing lengthy definitions of each, which I won't cover today. This again followed the Nuremberg Charter, which considered the same crimes. The Tokyo Charter also established that for all crimes there would be individual responsibility, meaning the accused would not be able to use a defence if they were following orders from their superiors. Once again, this was first established in the Nuremberg Charter. In summary, the creation of the Tokyo Trial's jurisdiction is traced back to Article 10 of the Potsdam Declaration, which again explained that stern justice shall be meted out in response to Japanese crimes during the Second World War. The Instrument of Surrender and Special Proclamation developed the jurisdiction until it was formally established in the Tokyo Charter on the 19th of January 1946. And it has also been shown that the jurisdiction of the Tokyo trial was modelled on the earlier Nuremberg Charter and trial, with Tokyo borrowing points directly from the Nuremberg Charter. Now moving on to some of the challenges which were posed to the Tokyo trial's jurisdiction. Firstly, it is considered common practice to challenge an international criminal or military tribunal's jurisdiction, with Nuremberg, Tokyo, former Yugoslavia, Rwanda, and the Special Court for Sierra Leone all having had their jurisdiction challenged by the defence. Nonetheless, it is still relevant to discuss these challenges to understand how the judges responded. Following the formal reading of the indictment in the court, the defence at Tokyo posed several challenges against the trial's jurisdiction, the most famous of which are that crimes against peace and crimes against humanity were not internationally recognised before or during the Second World War or when the Potsdam Declaration was published. Therefore, the defence believed the trial should be restricted to conventional war crimes only. Secondly, the judges were representing the victorious nations over Japan, and therefore the accusers were denied a legal, fair and impartial trial, as was stipulated and promised in the Tokyo Charter. Therefore, the defence believed the trial was impeding its own jurisdiction from the off. It took until the majority judgment was delivered on the 4th of November 1948 for the judges to decide on their response, over 2 years after the defence first challenged. The judges had squabbled privately in their chambers over how and when to respond, foreshadowing the mess which was to occur when writing the majority judgment. In the majority judgment, the judges understood the Tokyo Charter as a decisive and binding document and believed they were formally bound to reject challenges questioning the law or crimes established in it, therefore throwing out the first challenge. In line with the majority judgment at Nuremberg, the Tokyo judges cited the Pact of Paris from 1928 when providing a rebuttal to accusations of victor's justice and the creation of laws after the fact. They argued that any country who had signed or adhered to the Pact of Paris, which included Japan, had unconditionally condemned recourse to war for the future, although there was no explicit reference to any punishment for breaking the pact in the pact itself. Nevertheless, the judges believed that even if the crimes had not existed, those breaking treaties and attacking neighbours without warning must know that they are doing wrong, and so far from it being unjust to punish them, it would be unjust if their wrong were to be allowed to go unpunished. The Tokyo majority judgment definitively concluded its section on jurisdiction by stating that challenges to the jurisdiction of the tribunal wholly fails, effectively arguing that the jurisdiction of the Tokyo trial and the Tokyo Charter overall was unimpeachable. However, through the 5 separate opinions published by judges at the Tokyo trial, it's clear that there was disagreement surrounding the jurisdiction of the trial itself. As an example, the Dutch judge, which I'll come on to in more detail later, refused to accept that the Tokyo Charter could include crimes which had not been recognised previously in international law. And while he acknowledged there were several references to crimes against peace in treaties prior to the Tokyo trial, he claimed that waging an aggressive war had never been criminalised, because there had been no punishment ever established for being found guilty of it. Likewise, India's judge also believed that the Charter could not create new laws and that aggressive war was not a legitimate crime. And even if it was, Powell believed it was not right to apply individual responsibility to the waging of aggressive war, because he believed the fault should lie firmly with the states, not the individuals. So moving on to the next section, which will contain brief biographical sketches of General Douglas MacArthur in relation to his role as Supreme Commander of Allied Powers, or SCAP, and the judges of the Tokyo trial. This will cover some key information surrounding their experience and appointment, but finishing upon them being appointed as considerations of their contributions to the proceedings and judgment of the Tokyo trial will be considered in later chapters. So beginning with General Douglas MacArthur, who is described as a decisive, high-profile figure who was commanding in both stature and personality and always confident in his ideas and actions, whilst also being attracted to the drama and the dramatic. Furthermore, he's also described as the hero of World War II, the de facto sovereign of post-war Japan, and the centre of controversy during the Korean War. Upon the conclusion of World War II, MacArthur was appointed Supreme Commander for the Allied Powers and would fulfil the role of SCAP for 6 years, overseeing the occupation of Japan and the Tokyo trial. His appointment as SCAP came reluctantly, with few leaders in the Roosevelt and Truman administrations holding MacArthur in high regard. Moreover, President of the United States Truman personally disliked MacArthur, finding him to be arrogant and insubordinate. Despite this, Truman appointed MacArthur because he was the most experienced and best qualified officer available for the job. With MacArthur having completed several tours and having held several roles in Asia across his career, gaining a reputation as one of the Army's most perceptive and experienced authorities on the Far East. In relation to the Tokyo trial, MacArthur, in theory and according to the Tokyo Charter, had the power to appoint judges, prosecutors, and the president of the trial. However, in practice, MacArthur was unable to utilize all these powers. The Allied countries involved in the trial had nominated candidates to be their judicial representatives, and rejecting said nominations would have been seen as America overstepping its bounds and attempting to take control of what was being presented as an Allied trial. Meanwhile, the appointment of Joseph Keenan as the chief prosecutor was down to President Truman. Possible reasons for the discrepancy between the powers of MacArthur in theory and in practice include that his priorities as SCAP were disarming and demilitarizing Japan, not the Tokyo trial. Also, MacArthur had become disgruntled with the Tokyo trial before it even started, as he had unsuccessfully campaigned for a quicker and smaller American military trial, focusing purely on Tojo and his cabinet as defendants accused of the crime of illegal murder of citizens from nations Japan were at peace with. This proposal would have enabled decriminalization of the Japanese attack on Pearl Harbor, which was his main focus, among other events, whilst also avoiding the perceived hassle of involving the Allies in a large-scale international tribunal. This was rejected by President Truman, who preferred an international tribunal as part of America's global vision of outlawing war. Also, when MacArthur did try a few times in the early stages of the Tokyo trial to wield some influence, first by proposing he should make an inaugural speech formally opening the trial, and second by suggesting he give advice to judges from time to time in his role as the creator of the charter, both of his advances were promptly rejected by the judges. And in particular, the president of the trial threatened to resign upon hearing this. Now moving on to the two American judges. As a result of the abrupt resignation of the first American judge appointed to the Tokyo trial, there were two American judges in Tokyo, a decision which caused embarrassment for America and controversy for the trial. Higgins was America's first and often forgotten judge owing to his early resignation. His appointment was extremely unpopular with Chief Prosecutor Keenan, who was disappointed that he did not have much reputation outside of his home state. As a result, Keenan believed Higgins would not match up against the higher caliber appointments of the other Allied countries, and his disappointment led him to write into the US War Department on several occasions pleading with them to withdraw Higgins' nomination. Gary Bass, who I reviewed earlier, supports a dim view of Higgins, describing him as fecklessly weak and a noticeable downtick from the American judge at Nuremberg. Higgins resigned after a few months of the proceedings due to concerns over the protracted length of the trial, having been promised it would be concluded within 6 months, lack of quality among the prosecution and defense teams, and due to the abrupt death of his replacement for his state superior court, with Higgins feeling duty-bound to return to America. Kramer was America's second and arguably Tokyo's 12th judge, having arrived on the 22nd of July 1946 to replace Higgins. Kramer arrived with lots of relevant experience and prestige, having taken part in planning the German war crime trials for America. The decision to replace Higgins caused concern over whether America were acting in contempt of the Tokyo Charter, which did not explicitly allow for replacements. Even those involved in the trial were split, with Australia, Canada, the Netherlands, the United Kingdom, and in New Zealand believing that MacArthur had no power to replace a member of the bench. Moreover, the governments of Britain and New Zealand formally complained to the United States about the inappropriateness of naming a judge mid-trial. Meanwhile, in the opposite corner were France, China, and the Soviet Union, who believed the trial was a Big Five responsibility and that Americans must be represented. America, unsurprisingly, also believed that they had the right to replace Higgins, citing the fact that they had carried a burden alongside China of the war against Japan, and the infrastructure of the trial had largely been established and paid for by America. The legality of Kramer's appointment was debated in detail on the 22nd of July 1946 in court, as the defense argued that Kramer was not eligible to participate in the trial, the charter not allowing for replacements to be appointed. They also took issue with Kramer having missed too much of the proceedings and his high-ranking role in the US military, which meant he would not be able to be impartial. As a result, they called for Kramer to be disqualified and a mistrial to be declared, with new judges to be appointed. It took only a brief recess of 15 minutes for the judges to decide Kramer was eligible to sit, with the judges stating that nobody had the power to challenge the appointments made by SCAP, and therefore the motion was dismissed. Moving on to Australia's Webb. Webb's most relevant experience of the Tokyo trials was his appointment as the president of the Australian Commission investigating Japanese war crimes in 1943. He would continue in this role until the end of 1945. In this role, Webb would speak to over 400 witnesses and examine over 100 pieces of evidence related to Japanese war crimes, from which he uncovered significant evidence of Japanese war crimes. This experience led Webb to being the obvious choice as Australia's judge. The reason behind MacArthur choosing Webb as president of the trial is murky and is considered a controversial appointment. Some differing theories include point to the fact that MacArthur and Webb had become acquainted in 1944 when MacArthur was stationed in Australia, and therefore MacArthur had a professional knowledge of Webb. Alternatively, MacArthur had intended to appoint the American judge as president, but changed his mind when he was also disappointed by the appointment of Higgins. Therefore, Webb, again a judge he knew the most about, was the safest choice. And a third viewpoint suggests that MacArthur chose Webb to pay respect to Australia's war efforts and to remove the pressure from himself to have to choose between the American and British judges, not wanting to annoy either side. Overall, the appointment of Webb was a controversial one, owing to his prior involvement of investigating Japanese war crimes. As a result, his appointment was challenged by the defence on the 6th of May 1946, on the grounds that his involvement in investigating Japanese war crimes would influence the decisions on the Tokyo trial, especially owing to his role as president. On receiving the challenge, Webb removed himself from the proceedings, and the remaining judges heard, considered, and ultimately denied the challenge, once again citing that no objection of any member of the tribunal can be sustained, as per SCAP's power prescribed by the Tokyo Charter to appoint the members. And this is the same logic which was used to deny the challenge against Kramer. Moving on to Canada's McDougall. Canada viewed the punishment of Japanese war crimes as of great importance, having suffered more at the hands of the Japanese than any other nation it fought against. However, their appointment to the trial is seen as uninspired by most. McDougall is remembered as a polite and patriotic man, but he ultimately possessed a relatively undistinguished record as a jurist, having only been a judge since 1942. And when paired with his complete lack of background in international law, his appointment caused concern about his suitability for the role in Canada and abroad. As a result of his lack of relevant experience, it is predominantly thought he was appointed more so due to his strong working relationship with then Canadian Prime Minister. And the Tokyo trial is largely seen as the highest point in his judicial career. Next up is India's Powell, who is perhaps the most well-known person associated with the Tokyo trial, being presented as the fly in the ointment of the trial due to his dissenting opinion, which found all of the defendants not guilty. The precise details of Powell's dissent and his motivations behind it will eventually form part of a future chapter, but once again, this is a work in progress due to the dissent being over 1,200 pages long. After Britain managed to get the Tokyo trial expanded to 11 judges, which I spoke about earlier, there was very little time to find a suitable Indian judge due to the US not wanting to delay the opening of the trial. As a result, a hurried and somewhat haphazard search ensued. The British Raj asked for any retired or active High Court judge in Bombay, Madras, Lahore, or Calcutta who might be willing to take on the role. Powell is said to have jumped at this opportunity, seeing it as a good way to progress his career. Due to the rush, there was no time to ensure Powell was a suitable candidate or complete any sort of vetting process. And Powell was appointed purely on his expression of interest and his rank as a High Court judge in Calcutta, despite having little to no relevant experience in international law, with his background instead being in Hindu and Indian law. Powell arrived in Tokyo having already missed 2 weeks of proceedings and the opportunity to deliberate and discussed with his fellow judges prior to the commencement of the trial, and he arrived at strong anti-colonial feelings. For example, during the conclusion of World War II, Powell had spoken openly in support of Indian independence against British rule, and has been accused by some, including Tatani, of supporting and even collaborating with the leader of the Indian National Army, who themselves had collaborated with the Axis powers against British colonial rule. However, Gary Bass argues that there is very little primary evidence to support this claim, and therefore it is possible this connection was more of a presumption with Powell and the leader of the Indian National Army both coming from the Bengal area, and was a presumption because of Powell's anti-colonial views. Next up is Lord Patrick from the United Kingdom. The UK had a great deal of pressure on their appointments, requiring them to be of a strong caliber, matching or exceeding the appointments made by the United States of America, with it being believed that the Tokyo trial represented an opportunity for British prestige to be rebuilt after embarrassing losses to Japan during the Second World War. However, there was also the issue of not wanting to put too much pressure on the English judicial system, which was still dealing with the loss of the British representative at the Nuremberg trial. As a result, talks ensued about where the United Kingdom's judge for Tokyo should come from. Candidates from Britain's overseas territories were considered before it was eventually decided that a Scottish judge would be chosen. Patrick was on a list of 3 suitable Scottish candidates, and he was eventually picked due to his status as the only bachelor of the 3, meaning he did not have anyone or anything to distract him back in Scotland. By this stage, Patrick had gained a strong reputation for having a sharp mind and forensic skills, which helped him gain a seat on Scotland's equivalent of the Supreme Court. He was also highly regarded by his peers, with him being considered to have a wide knowledge of law and of legal principle, paired with a calm, balanced mind, and was a patient and courteous man, whilst also not allowing any time wasting in the courtroom. The penultimate judge is New Zealand's Northcroft. New Zealand at the time were a relatively young country in terms of geopolitics. The Tokyo trial represented an opportunity to improve their international standing and be involved in the post-war settlement of Japan, which they had a special interest in due to its impact on the maintenance of peace and security in the Pacific. As a result, New Zealand were eager to ensure their appointment to the Tokyo trial was of a sufficient standing to make the trial a success. In the end, they settled on a judge with a distinguished military career, having served in both world wars, and somebody who was well respected in his legal circles, having been appointed to the New Zealand Supreme Court in 1935. However, Northcroft notably did not have any expertise in international law, with it being commented that he didn't need it, being from New Zealand. And then, as part of the final section of the judges, I've grouped the 5 remaining judges, which my research does not focus on so much, being as they're from outside of the British Commonwealth. This is the judges from China, France, the Netherlands, the Philippines, and the Soviet Union. And despite not focusing on them, I thought it was still relevant to provide a brief introduction so as to have an understanding of everyone on the bench. Beginning with China's judge, Mai, who was involved in the trial while China were in the midst of a civil war between nationalist and communist forces. And towards the end of the trial, Mai was having to consider his future of either sticking with the nationalists or trying to switch sides and to the communists. Despite this, Mai was considered as being a brilliant lawyer during the trial and previously was a prominent attorney. And he excelled in his ability to speak English. And because of these characteristics, he was considered a name who the Allies would respect. However, he lacked a practical courtroom experience leading into Tokyo of some of the other appointments. Gary Bass has several really good chapters on Mai in his book, Judgment at Tokyo, which I would highly recommend. Next is France's Bernard. For France, the Tokyo trial served as an important tool in re-establishing its position as a world power. Additionally, France were insistent on nominating a judge with colonial experience who could control the flow of information relating to the French colonial project in Asia, as they were worried about investigations into their conduct in Asian colonies. Bernard was chosen for his experience, availability, and arguably most importantly for his loyalty, as France trusted him to deflect and block any investigations or questions into their practices. This is all despite Bernard not being able to understand or speak either English or Japanese, which were the trial's two official languages, and as a result, he relied on a translator. Next is the Netherlands' Röhrling, who was the youngest judge in Tokyo, having been appointed when he was only 39. Prior to his appointment, Röhrling is quite open about his dislike for international law, being quoted as calling it uninteresting and dull. In addition, as a result of his young age and lack of interest in international law, Röhrling was surprised by being offered the role. He's quoted as saying he had no experience of international law, had never been to Japan, and he believed his only qualification for the role was that he had some expertise in the criminal law of the Netherlands East Indies. Despite these concerns, Röhrling is now remembered as a high caliber appointment at Tokyo and is remembered as one of the Netherlands' greatest international lawyers. The penultimate judge is the Philippines' Harinilla. Harinilla spent a large portion of his younger life in America, attending American colleges and universities, leading to him becoming increasingly pro-American in his views and beliefs, something which was noticed by his peers in Tokyo, especially Röhrling, who made quite a few comments about Pao and Mai being the only true Asian representation. Harinilla was a victim of the Bataan Death March whilst imprisoned by the Japanese during World War II. Unsurprisingly, this led to the defence challenging his appointment, arguing that due to his experiences during the war, he had a personal bias, meaning the defendants would not be given a fair and impartial trial. The challenge was once again rejected on the same grounds as the previous two, with the judges being consistent that there is no power to set aside an appointment by General MacArthur. And the final judge is the Soviet Union's Zarianov. Zarianov was considered a fully indoctrinated supporter of the Stalinist regime at this stage, having helped preside over several purge trials in the 1930s as a judge. Therefore, he was considered a safe appointment by the USSR to represent their interests during the trial. However, similar to Bernard, he could not understand or speak English or Japanese and relied entirely on a translator to engage in discussions with his peers and to follow the trial. Now I will cover some preliminary conclusions from my research so far. First of all, the decision to expand the number of judges involved in the tribunal from 4 in Nuremberg to initially 9 in Tokyo, and then eventually 11, with the final 2 being added after the proceedings had already started, meant the Tokyo trial was always going to prove harder for a consensus to be reached, as more opinions and more varied opinions had to be considered. While the inclusion of additional judges in Tokyo improved how representative the trial was, and was a step in the right direction as it expanded the amount and type of nations involved in international criminal law, taking power away from purely the big 4 of the US, the UK, the USSR, and France. It also meant there were language and legal barriers for some of the judges to get over. As I said, for example, several of the judges did not speak or understand English or Japanese. Secondly, the shadow of Western imperialism loomed over the Tokyo trial and influenced its proceedings and outcomes. This is most obvious through the character of Pao. As I said, Pao produced a significant dissenting opinion, partly motivated out of distaste for Western imperialism and the fear of its growth after the war. In his dissenting opinion, he alluded to the judges involved in the trial having unconscious bias which was impeding the trial, and the emergence of race, politics, and imperialism as key themes behind the scenes. Lastly, the disputes and lengthy delay surrounding the judges' response to challenges to the trial's jurisdiction showed a disjointed judges' bench from the beginning, as the judges could not even agree whether the jurisdiction and crimes they were enforcing were legal and valid. It also foreshadowed the future issues surrounding the conclusion of the trial, which, as I said, saw 5 judges submit separate opinions. Yeah, thank you everyone for listening.
Thank you. Very good. Great overview of your research, and also you grounded very well in the historiography and a great profile of the key participants. As usual, we call for questions from the floor, particularly from the people that are here in campus first. Then we'll take questions also from the people online. You can just raise your hand, or if we don't see your hand for any reason, you can just unmute yourself and put a question. But we'll start with people here in campus first. Yes, Chris, of course.
Thank you. That was fascinating, and it was interesting to hear about the tension between American leadership in the person of MacArthur and the Allied judges who were kind of pushing back at times against his interference and against American decisions, for example, with the
Replacement of the judge, yeah.
Being replaced. I suppose the most controversial decision taken by the Americans, and it wasn't just MacArthur, by the US in relation to the trial, was the decision not to try the Japanese emperor.
Yes.
Has your research so far shed much light on kind of Allied pushback against that decision, say by the Australian, New Zealand, British judges?
Yeah, so that was one of the major focuses of the president of the trials, Webb's separate opinion. He believed that for the trial to, I guess, in a sense, for it to be legitimate, they had to have tried Hirohito as kind of the figurehead of Japan. So he was very vocal on that, and that was something which received some I think the right word. America weren't best pleased about him making that known, basically. Hirohito was on Australia's original list of Japanese war crime suspects. So they made their opinion very clear, and then Webb kind of reinforced that in his separate opinion at the end.
In contrast to the Nuremberg trial, the extent of research in the trial is obviously much more sparse and is more difficult. So it's very interesting that I can show that for that reason. I would say also the comparison, obviously the Nuremberg trials were, and you mentioned that as well, the offensive of much greater magnitude in a way that makes the Tokyo trial more interesting because the questions are therefore more poignant regarding that, or more difficult. Some of the same issues, as we said, were mentioned in the as well. And I think it's interesting maybe to look at some of the writing of the issue of the retroactivity of offenses, which obviously was there as well. And there was a strong argument by prosecutor regarding that, and some interesting writing by Stanley Paulson. The issue, but again, I think it becomes a more discussion with Tokyo because of the magnitude of offenses, which actually makes it much more tricky. There were, I don't know if you've come across that, but there were other smaller trials that British and American forces held ad hoc of capturing Japanese POWs. They're difficult to access, and because these were of an even smaller magnitude, the same problems become more pressing. And I believe these are answered. And then the question that you look at of the judges themselves is interesting, again, because of this question can this be a trial? And it is victor's justice. There's no way to around. But specifically for the Anglo-American judges, it's interesting. Well, there were reasons to challenge their impartiality. However, the answer to that was, well, there's nothing about that, nothing about that in the act that sets up the tribunal, so that's the end of the story. But in fact, the domestic British laws have been a case in there is something called the rules of natural justice, which say a judge cannot be biased. That's regardless of what the act setting up the tribunal says. So I think at least I counted 3 people struck down for maybe not actual bias, but what is called apparent bias. Again, that's exactly what international is also somewhat different because there's always going to be some involvement. So every international lawyer is going to be somehow involved of the day, especially if it's a world war. It would be hard to find someone who's completely. It's something about that. Maybe that Dutch judge rated international law, but other than that,
right, you're raising lots of issues. I'm not sure the people at home can hear you even. So, but for the people at home, she has been raising issues regarding Nuremberg and perhaps some aspects of and issues that were discussed in Nuremberg could also be of relevance in the Tokyo trial. And also, you pointed out some things that should be bear in mind when you look to some of the specific judges and perhaps looking also into national law in the case of Britain. So if you want to address some of all those issues. Do you want to say anything about regarding all these issues?
There's a lot there.
Yeah.
I think yeah, you're 100% right about it being almost impossible to find somebody without any level of bias in this situation. And I think Keenan even makes a comment about that in his opening address in response to kind of accusations of bias, saying that he makes some slightly silly comment about having to leave Earth to find somebody who didn't have any bias or opinion either side of the war. So it's certainly something interesting to look at. Like you said, several of the judges certainly had perceived biases, even if they tried their best for it not to influence the trial.
I'm going to take one question from the people online because I've been waiting. Adam Williams, you have your hand raised. Do you want to unmute yourself and give us your question, or are you writing it in the chat? We hear you very badly, but have a go. Oh my goodness, we cannot really hear you very well. Can you type it in the chat area? He's going to try to type it. In the meantime, we can take your question, and if Adam can write it, we'll get your question after the question here in campus. Okay, yes.
Thank you very much for talking, and particularly on the backgrounds of some of the people there. That was really interesting. To what extent was the trial influenced by the Cold War? As there was judges from the USSR who was a dedicated Stalinist who had participated in the trials and the purges of the 1930s. And also, you mentioned that there was a struggle for the Chinese judge, if I'm correct, May, who was had the issue at home of the Chinese Civil War, which between the Kuomintang and the Communist Party. Can you please expand on that sort of struggle in his terms, and what did he do in later life? Did he return to the mainland, or did he go to Taiwan? Or
Yeah, I can touch on some of them. Obviously, not my main focus, but regarding the Cold War, it was the strenuous relations were apparent, and I think very early on, I can't remember the exact dates, but America decided that it wouldn't take part in any more Allied tribunals like this during this period, with it originally being posed that there'd be a few to follow. That kind of showed that those Cold War relations were apparent. And regarding like I said, Gary Bass has some really good chapters on him if you're interested on him. But I believe he returned to China, where his family was, and he didn't have a great time, I think is the easiest way to summarize that. But yeah, I'm pretty certain he returned to China. Yeah, Bass has a particularly good chapter on his post-trial life, which I'd recommend.
I'm not sure if Adam managed to type his question at home.
Can't see anything.
Yeah, we can see it. Can you see it in your? Okay. Sorry. Sorry, Adam, we cannot really hear you at all. If you could type your question in the chat. That's better.
Can you hear me?
Yeah.
Okay, cool. So the question I did type in the chat. I don't know why it hasn't come up for you guys.
No, it has not come up.
All right, then. So the question is, what drew you to the subject? What was your interest in it? Why do it for your PhD?
Yeah. So I think what first drew me to the subject so I've done my undergrad and MA at Winchester, and what first drew me to the subject during my undergraduate was that it was something I knew nothing about. So it was something that kind of like intrigued me. 'Cause I think when we learn about World War II and this kind of area in school and colleges, it's very much focused on the German theatre of war. So it was something completely new to me. And my supervisor, Chris, did several lectures on it, and I enjoyed his lectures very much. And I took it as my MA, well, not this exact subject, but I did a subject on Far Eastern prisoners of war for my MA dissertation. And this was kind of a somewhat natural progression from that. So yeah, it was mostly something completely new, and therefore it's a challenge which I enjoyed. And many thanks to Chris's great lectures on it.
I'm curious as to how much your thesis will be focused on post-trials and lengthening.
So it's still the latter parts of the thesis are still work in progress. The plan is to kind of follow the natural progression of it. So to look at the prosecution, then the defence, and then I hope to do some chapters or a chapter on kind of the legacy of the British Commonwealth judges, to look at kind of how the trial impacted them and their careers. So in the early stages, it was a plan. It's proven slightly difficult based on sources. So it's something we've slightly gone away from to rely more so on the trial primary sources, which are readily available now online. But it's something that is very interesting as well. So
you mentioned the Commonwealth block of judges, and obviously I'm assuming that didn't include Judge Powell.
No.
So can you tell us about the dynamics of the other members of that block, and who emerged as a leader of that block, and how it worked as a kind of as a group reaching some kind of consensus in the trial?
Yeah, so the block was the British Judge Patrick, McDougall from Canada, Northcroft from New Zealand, forgot New Zealand, and Kramer was also involved, despite being American and therefore not strictly in the Commonwealth, but it was mostly led by those three Commonwealth judges. And then within there, Patrick kind of emerged as one of the leaders, I think perhaps owing to his seniority and probably to Britain's seniority as well, within the British Commonwealth, kind of putting him in a natural leadership role, I guess. But Northcroft was also quite an influential judge. McDougall, I think the part of him was one of the briefest, and that's because there's not a ton about him, and he didn't massively get involved or become vocal during the trial. Not at this point, I'm not 100% sure why that is, whether that was just his person or not feeling able to. And whereas maybe you'd expect Kramer as an American to be quite front and center, there's a feeling that he felt that he had to be a bit more reserved owing to the controversy surrounding his appointment. And therefore, if he was front and center and leading and writing the majority judgment, that controversy would have been honed in on the judgment.
How about William Webb?
He was quite quickly ousted, it seems, partly because of his role as president, because he had started writing the majority judgment and then was kind of usurped in favour of the Commonwealth bloc. And that's why he went on to write his separate opinion.
I have a question in the case. You mentioned how important it was for the appointment of the UK judge that should be somebody of high caliber, and that it was early decided that should be somebody from Scotland and should be an expert in Scottish law for some reason. I wonder why. I mean, it had to do with the fact that the Scottish law is different to English law and perhaps more akin to continental European law, and that gave him a sort of international flavor. Otherwise, why Scottish? Why it had to be Scottish?
So I think the emphasis was more so on it not being another British judge to leave, or sorry, English to leave the English judicial system too light, because they were still dealing with the English judge at Nuremberg being absent. So therefore, I think maybe Scotland, like you said, gave them a little bit of international flavour, but also some home comforts, because originally they looked across their kind of international territories, and even like a different Indian judge to Powell was considered at one point, but it was considered, I think, too much of a risk, whereas Scotland was that perfect kind of in between, where, like you said, it had a little bit of international flavour, but also a safe home comfort.
Right. And regarding the Indian appointment, I mean, you made a little bit of a criticism that he didn't have background in international law. But that looks to me like was the case in most of these people. I mean,
Yes,
actually,
yeah,
none of that. So it's not just himself. But also, I wonder how was the context of his appointment regarding what was happening in India at the time, and regarding the British case, and how that was playing at the time. So
yeah, perhaps what I should have made more apparent was that in a lot of earlier texts, such as Minir's, Powell is heralded for having international law experience, but since Bass's book, he's kind of the only word that's coming into my head is poo-pooed that.
yes.
And has kind of given evidence that his background was actually in Hindu and Indian law, which does make sense. As for the Indian independence, obviously him and the Filipino judge kind of went through slightly similar experiences of arriving in Tokyo as a judge of a dominion or a colony, and then leaving as a judge of a newly independent country. I think that certainly did influence how he was very kind of vocal against colonialism and Western imperialism. And many people believe that he arrived in Tokyo with basically his judgment set in stone, and that's kind of backed up by the fact that he didn't attend that much of the court. He was often absent already writing his opinion, which was, like I said, based heavily on his kind of anti-colonial and imperialism views.
But also because he was also returning to an India that was different. So he also probably was thinking of his own future, for where he was going. Yeah. That's... More questions? Yes.
Just to follow on from that a little bit, I get the impression from the way you describe it that the selection of these judges was really quite a kind of random process. It wasn't, they weren't selected because they could particularly be relied upon to come up with a any more thoughts on why that was? Was that just an assumption that whoever they chose would be a sensible chap who would come up with an answer, or did people genuinely not know what answer they were expecting to come out?
Yeah, I think there was no, as I said, there was no central power such as MacArthur, who was appointing the judges. So it was up to each nation. And kind of like, for example, what I mentioned about France, some nations had their own kind of agendas attached to the Tokyo trial. For example, they wanted a trial who they a judge who they trusted not to allow too many kind of questions or looks at their own kind of colonial practices. So that influenced some of the appointments. As well, I think there was just overall a lack of specialists in international criminal law at that stage. It was still a very young subject. There were lots of things, and like I said, also with Patrick, obviously he wasn't picked purely because he was a bachelor, but when it came down to the final three Scottish judges who were seen as pretty much on level pegging, the final kind of deciding factor was the fact that he was a bachelor and therefore had nobody who would force him to come home, like some of the other judges returned home on several occasions due to like family commitments. So there was lots of slightly odd decisions behind the picks, and like you said, other factors other than their expertise influenced them.
Factors.
Yeah, sometimes. Yeah. Whereas nowadays, you probably hope that the picking would be a bit more structured and on evidence and things like that. But yeah, it was a bit more incidental.
Yes.
So just following on from Steve's point, it is interesting that but they're not very high caliber, most of these judges, are they? And it was probably difficult. I mean, do you think it was difficult for governments to kind of encourage judges to go and do this because they didn't see it as much of a career opportunity? Nuremberg would have been a major
career maker, yeah,
because of all the because they're trying notorious Nazi war criminals because of the publicity around it. Whereas Tokyo was it was very peripheral to the people's kind of exceptions, perhaps except for the Chinese judge and the Filipino judge, but others. Do you think there was a reluctance to commit time to this because they didn't really see that it was going to enhance their legal careers very much at all?
Yeah, I think so. And I think probably Higgins is a good example of that. Obviously, he resigned partly because he wasn't willing to commit more than 6 or so months that he was originally told by the US War Department. So when he believed it was clear that trial was by no way was going to be concluded in 6 months, he obviously quite quickly resigned. Obviously, there were other reasons. But yeah, I think for some, it probably was a secondary or a less prestigious maybe appointment than Nuremberg. And also the fact that, like, for example, Kramer was called out of retirement to be the second American judge would indicate that no one else in active duty was a suitable candidate, or at least wanted the role.
More questions and so on? Well, just yes.
Yeah.
Yes, and we have Javier that is saying that we'll be interested in hearing more about in the future, particularly with the case of the Indian judge, of course. So, anything? Yes.
The judge, multinational prosecution team, as it were.
Yeah.
Japanese, or as in the case of some of the Singapore war crimes trials provided by the Allied nations.
Yeah, so the prosecution was led by the American Joseph B. Keenan, and then each nation that appointed a judge also appointed what was called an associate prosecutor. So that's something I'll be looking at in my next chapter, looking at their involvement. As for the defense, it was American and Japanese members.
So there were.
Yes, there were, yeah. Although the defense, it's quite muddy waters because there were large-scale resignations and lots of the defense arrived quite late, and there are issues like some in the historiography claim that in terms of that perspective it was kind of doomed from the start, and that they weren't given a fair, the Japanese defendants weren't given a fair kind of chance at the trial.
British and Indian prosecutors and a British military defence advocate as well. Which seems a bit interesting.
Yeah, that is, yeah. Yeah, so obviously, and the Japanese defence were needed too because they could speak Japanese, as simple as that as well.
Perhaps the last one is about language. I mean, that you were saying about the problem of having somebody who was able to understand Japanese. I mean, how you navigate the problem of language? Obviously, that you're investigating particularly the Commonwealth and the British side of things, but do you have, any block with the things coming from Japan? I mean, you mentioned that originally the trial perhaps was overlooked because of the language issue.
Yes, yeah.
So do you have any barrier there?
So the transcripts of the proceeding of in the chambers, which is 2 separate things, and then all the sources I looked at about the jurisdiction, such as like the instrument surrender, are all very readily available in English and online now, which is obviously very good. They're all on a database run by the International Criminal Court. So it's also good that it's a reputable site. So that doesn't pose any language issues. It had posed, they're all quite somewhat recently digitized. So it originally posed some issues accessing them, but now that's no longer a real issue. I mean, in terms of the Commonwealth side of things, the biggest issue will be the primary sources surrounding the Indian judge, which obviously aren't always or predominantly in English. That's an issue I will face soon.
Right, good. How you're going to be navigating that one?
That will be a work in progress.
Okay, otherwise Google will help in the initial stages, I guess. Yes, good. Right. Any questions? In that case, thank you very much, Michael. You have given us a fantastic talk, and it's a great way of ending our series for this year. So thank you very much. And thank you, people at home, too. And we have passed all your messages of support, and we're going to be leaving now. Thank you very much.